all of the special statuses, but it looks like the sexual orientation and gender identity is missing from there as well. And I'm wondering if that's something else that could be factored in as under those protected grounds. It's listed on page 3, but it's not listed in this section under the fundamental principles, which could potentially dilute the importance of including it on page 3 if it's not consistent throughout.
That is very well noted. I think we'll take into account. Any other concern? I see.
Thank you. I'm concerned about the non-discrimination where we specified the HIV status. Can't we put health? Because people have been discriminated not only on HIV status, but maybe on COVID grounds or whatever health issues. So maybe if we just specify HIV, I just feel that, what about other conditions, other health conditions?
I think we take into account, and I think health status is very important. One of the reasons HIV was singled out is because of what we're also taking into account what the SDGs are saying with regard to HIV status, and to ensure that it comes out very definitively. So would it be helpful if we leave HIV status as a defined prohibited ground of discrimination and also add health status there? I see another hand.
Yes, good morning, everyone. I'm sorry, it's a difficult topic, but I have to say something on the issue of sexual orientation. Sexual orientation. We have had some debates in some meetings, technical meetings, not those decision-making bodies in SADC with respect to the issue of sexual orientation. So I've noted in the guidelines, one of the speaker here, somewhere, with your permission, item 5, minority rights, where we are talking, we'll get there later, where we are talking about sexual and gender minorities. And in section 1, somewhere there, we are explicitly talking about section 1 definitions, talking about sexual orientation. What I can say in summary, there is no agreed or a common position on whether we can reflect those terms in our legal policy and the strategic documents. And we are normally guided by, as we have been saying here, by SADC protocols, those ones in force. And the relevant one is the protocol on gender and development. It talks about 2 sexes, and I'm sorry to say this, we know them. So I don't know how this one will be perceived if these terminologies continue to be in it's a difficult subject. We know we are heading that direction, but some of the members are already there, some are not there. So to avoid, or to at least to bless these particular guidelines, maybe we may keep quiet on those ones, because somewhere we are saying and other status, and it may suffice, and the other status, and we keep quiet there. But if you mention this kind of terminologies somewhere, I don't know, in the SADC Parliamentary Forum, how you treat them. But it may create some issues. Thank you. I hope I'm understood.
Very well understood, and my
Thank you.
colleague here would want to respond to that.
Yeah, I think Phineas quite noted, and we had the same problem when we drafted the Zimbabwean constitution back in 2013. And we were making a blueprint for government, and you did not want to be explicit, but you wanted to make sure that there's a basis for providing for the rights of everyone, despite what we know to be sexual orientation. So with what you say, I think you've provided the solution to say that end at the status. I would like also then to say that would give us a perfectly legal position to then explore any other status that may be affected in terms of their rights without necessarily using the terminology that will prevent our document from getting to the ears that we want it to get to. So I think at this stage in time, that might be a compromise, but I do sense as well that it's a policy level intervention that you make. And so I have to call upon Madam SG and her team to take note of this, because at the end of the day, like we said, the protocol is the guidance. But when we see that there's differences that prevent us from being more effective in protecting and promoting human rights, it is worthy to make recommendations. And I think that may be a proactive approach, which is the role of the Parliamentary Forum in advocacy and diplomacy. I still see some hands, so I think we would like some responses to what you said.
I think there was a first hand there. Please go ahead.
Good morning, everybody. Thank you very much. You know, I know there are some issues within the SADC region that are a bit sensitive to some people or some country, but as a member of parliament, if we are going to create such important document, especially legal document, then we have to stipulate what it entails. SOG is SOG. If we put marginalized, then at the same time, we cannot have targeted intervention. Sexual orientation is all over the world. And on top of that, they are one of the main indicators for the UNAIDS. And all countries have sort of endorsed those documents. So marginalized group is generalized. Let us be targeted. Let's sort of target our intervention in a manner that we know what we are stipulating. We know that we have different sexual orientations. Those people, most of the time, they are discriminated upon. And we have to find ways and means for them to have their own rights. They have their own rights, and at least not to be discriminated upon. So this is my view, Seychelles' view. And on the, where you mentioned social status, maybe we should add as well socio-economic status, because sometimes poverty creates discrimination within the particular group. Thank you very much.
Thank you very much for that intervention. I think we'll take into account. There was another hand.
Thank you, Mr. Moderator. Good morning. I just wanted to point out that when we were discussing on the gender-based violence model law, we had a long debate about the marginalized group and other sexual orientation group. And here today, I see in the document, we have any other status. It can cover marginalized group, but still we have to leave no one behind when we are talking about human rights issue, and especially non-discrimination. Thank you.
Thank you very much. I think that those seem to me like complementary contributions from the floor. Are there any other contributions from the floor, especially with respect to the aspect of sexual orientation and gender identity? Delegate from Malawi.
Thank you. Mine is not on sexual orientation. on a general provision, the very first paragraph, I just wanted us to be clear. There in unpacking the principle of non-discrimination, you've made reference to citizens. Grounded on the principle of equality, the principle of non-discrimination means that no citizen within a state should be excluded, marginalized, etc., etc. I was trying to cross-check quickly with a few constitutions in SADC. I think generally the reference is to no persons as opposed to citizens. So you may want to correct that, as well as the final paragraph that has also made reference to citizens and not necessarily persons.
We have noted that, and I think that that speaks to the first contribution that Chantel made, and I think we'll take that into account. We'll use person. Yeah, no, thank you very much. We'll take that into account, and I think that we'll try to be consistent in terms of language. Are there any other interventions? I see one hand there.
Oui. Bonjour tout le monde. J'aimerais que nous discutions un peu de ce qu'on appelle la discrimination positive. Le principe, c'est la non-discrimination, mais de temps en temps, on a tendance à établir des lois qui prennent la discrimination positive en faveur de tel ou tel groupe de personnes. Je voudrais savoir à quel moment c'est justifié et à quel moment ce n'est plus justifié pour ne pas provoquer le résultat contraire de ce qu'on recherche en définitive. Merci beaucoup.
I'm sorry, Honorable Delegate, I don't seem to understand the question. Would you kindly restate it?
Voilà, nous sommes en train de dire là maintenant que le principe, c'est la non-discrimination. Mais ces derniers temps, on a tendance à prôner ce qu'on appelle la discrimination positive. C'est-à-dire qu'il y a de temps en temps des lois qui favorisent tel ou tel groupe de personnes. Je vous donne des exemples. Chez nous, ou bien dans d'autres organisations internationales, il y a des dispositions pour les concours, par exemple, pour les candidatures à des postes de responsabilité, de favoriser plutôt les femmes. Voilà ce que voilà ce que j'appelle la discrimination positive. Il y a aussi d'autres dispositions qui sont en faveur des groupes minoritaires, etc. Ce que je voudrais savoir, à quel moment c'est justifié et à quel moment on doit mettre un terme à ce genre de pratique qui risque de violer le principe de la non-discrimination. Merci.
Thank you very much. I think that's a very important intervention. And as we were drafting the principles and guidelines, we focused on non-discrimination, that is negative discrimination. But I think the aspect of positive discrimination is also very important. And I think we'll take it into account when we are reviewing the document so that we can ensure that there is also a role that Parliament can play in ensuring that there is positive discrimination towards ensuring that specific marginalized groups can be brought to the center and away from the margins. Thank you. Any other interventions on the principle of non-discrimination? I see another hand. You may go ahead, sir.
Merci beaucoup de m'avoir donné la parole et bonjour tout le monde. Il y a peut-être une piste à explorer effectivement pour traiter justement cette exception à la règle, car il s'agit d'une exception à la règle, il faut bien le dire. Toute dispositions préconisant la discrimination positive, c'est-à-dire le fait de ne plus marginaliser une catégorie qui est considérée comme telle, c'est qu'on doit prévoir une loi. C'est donc l'acceptation, la validation par les représentants de la nation tels que les parlementaires. Voilà une voie et non pas l'exécutif. L'exécutif, c'est carrément interdit. Et on doit interdire de prendre, par exemple, un décret pour procéder à la discrimination positive. Et c'est souvent le cas dans nos pays. Merci beaucoup. Donc, il faut une loi pour, c'est-à-dire l'acceptation des représentants du peuple pour pouvoir faire la discrimination à l'intention des catégories marginalisées. Voilà donc une piste. Merci beaucoup.
Thank you very much. And again, I think it's a complementary contribution with respect to positive discrimination, and it's very well noted. Thank you. I think if there are no further hands on the aspect of non-discrimination, we can proceed to the next principle. Thank you very much. So we'll proceed to the next principle, which is the principle of universality of human rights. To a certain extent, the principle of universality of human rights brings to the fore some debate or what I would call some contestations. The principle of human universality really simply states that human rights are universal, that the rights that one person has in one area, in one country, in one jurisdiction, in one part of the world really are the same. It is really grounded on the principle of equality, non-discrimination, human dignity. It speaks to the fact that every person is equal or all people are equal, and therefore that the rights they hold are universal. So in including the principle of universality in the principles and guidelines, what we seek to achieve as a gold standard is to ensure that when laws are being passed, they take into account the fact that rights are rights everywhere, and that there are no rights that belong to a specific group or a specific jurisdiction or a specific part of the world, and that these rights cannot be recognized in another part of the world. We are really speaking about human rights, going to the very core of the definition of what human rights are, which are entitlements, freedoms that a person has by virtue of being human. Therefore, we are talking about there is nothing that divides the human race, but there's one thing that unites us, and that is our collective rights, and that is our individual rights. So in making laws, the principle of universality simply invites parliaments to take into account the fact that human rights are human rights because they're held by human beings, and therefore they're universal. And I think that the text gives more clarity to what I've said. Any contributions with respect to universality? Thank you, sir.
Thank you very much, moderator. Good morning, everyone. I think principle number 3 is a tricky one because we have talked of, is it okay now? We have talked of non-discrimination. Non-discrimination on religious grounds, beliefs, and the like. So are we not contradicting ourselves when we come to universality? I want to give an example of Africa and everywhere else. There is culture. So people should not be discriminated against the culture that they believe in. And then when you come to universality, it's like it's throwing away
that right that I have to have my own culture, which might trample on the universality issue? How would you deal with that one? Thank you.
Before we respond, are there any other concerns with respect to the principle of universality? I see none. I think that one important factor to take into account with respect to the principle of universality is that it speaks to the fact that human beings are the same everywhere and anywhere, and therefore that the rights they hold are also equally the same. However, that is not to say that there are specific rights that they may hold or that they hold which are specific to them. For example, we have economic, social, and as you have stated, cultural rights. So if there is a cultural right, there is a right that a specific group has with respect to a specific tradition, that right is theirs and it is held. But it is not speaking to the fact that this particular practice will contradict another practice, so to speak. It is respecting the principle of the fact that you have that specific cultural right. So for example, people in one part of the world have specific cultures. Those cultures must be respected by the law. And there are people in Africa have specific cultures, but those cultures are diverse. Those cultures are different. What the principle of universality simply says is that the diversity of those cultures should be respected in the law, and that there should be no confliction or there is no contradiction in terms of what those cultures seek to portray. So really it speaks to the principle that in terms of culture, cultural diversity should be respected. Let me give a very pragmatic example. If it is my culture to come to a meeting wearing blue, that right should be respected. And if it is another person's culture to come to a meeting wearing red, that culture should be respected. And therefore that the fact that I'm wearing blue, another person is wearing red, does not mean that we are conflicting. It means that the rules of the room accommodate all of us and are inclusive of our cultures and allow us to culturally express ourselves. So I think that's what the principle of universality seeks to do.
Sorry, thank you very much. Just as a follow-up, I still think there is a clash. Because if you look at that right of choosing your own culture, I'll pick again Africa. There are cultures where sexual orientation that we've just talked about is taboo in that culture. And then there is a right again to say these people have rights. So which right then overrides the other right?
I think there was another hand. Hopefully it will buttress the issue.
Yes, the gentleman raises a very good point because notably these guidelines avoid any discussion of plural legal systems where customary and religious laws typically govern family and personal status law or determine the makeup of certain religious and local customary governance and judicial structures. Some of them are anchored in the constitution of several SADC countries. So these plurality of laws have often contributed to persistent gender stereotypes and tribal affinity. We know, for instance, for women in some cultures, with land rights, they're discriminated against, for instance. And so given that there's a potential tension between such legal systems and human rights and gender equality principles, these guidelines might benefit from outlining the potential pitfalls and opportunities for harmonization of the two sets of laws.
Thank you very much. I think we're getting from translation that as we're making our contributions, let's do it a bit slowly so that thank you very much. So, Madam Speaker, you may proceed, but just give him a chance to translate as well.
Want me to repeat all of that?
That was the request. And so-
Okay. Okay, so these guidelines avoid any discussion of plural legal systems. That's where customary and religious laws typically govern family and personal status law or determine the makeup of certain religious and local customary governance and judicial structures. And these are anchored in the constitutions of several SADC countries. So such plurality of laws have often contributed to persistent gender stereotypes and tribal affinity. In the case of women, in some countries, customary law discriminates against women when with regard to land rights, or when you become a widow. So given that there's potential tension between such legal systems and human rights and gender equality principles, these guidelines might benefit from outlining the potential pitfalls and the opportunities for harmonization.
Thank you very much for that intervention. And I think we can also flag it because there's an aspect of the principles that speaks to the repeal of unfriendly laws, so that the aspect of harmonization comes in at that point. One of the things that the principles seek to do is not only to ensure that in the legislative process, parliaments take into account human rights based approaches, but also that there is a repeal of laws that have been traditionally causing marginalization, discrimination, and human rights violation. So through the process, there is a level of harmonization. I don't know if there are any other concerns, any other contributions on non-discrimination. I see one hand there.
Thanks so much. So I'm wondering, considering the discussions we're having now, whether the first statement under this principle, which to me sounds very conclusive, would still be accurate of us to say universality means that human rights are the same everywhere for everyone. Would it not be more appropriate to say universality expects that human rights should be the same everywhere and for everyone? Because it sounds to me with the discussions we're having that in real terms, does not appear that human rights are the same everywhere and for everyone.
I think that that contribution is very much appreciated, and I think that we can decide how we proceed. We would like to proceed on the premise that we are speaking in principle terms, and therefore principles and guidelines. And the principle is that human rights are the same. In terms of actualization, there may be a difference, but what we want is that the gold standard should be what we aspire to. So the reality is that human rights are the same. However, the lived experience is different from the actual aspired reality. And I think that we would really want to stick to the principle that men and women are equal, but we know that the lived experience may be different. The principle that human rights are the same for everyone, everywhere, but the lived experience may be different. And therefore, in proposing these principles and guidelines, we would like parliaments to aspire to the actual principle, which should be our gold standard, really. And I think that that is why we couch the language in terms of human rights are the same everywhere for everyone. We are also borrowing from different general comments, different treaties that have been ratified by the different SADC member states. And so we would like that that language kind of permeates. I don't know if that addresses the concern. Thank you. I see one hand.
I thought that universality means that human rights can be claimed by everyone by virtue of that they are human. I'm not very sure that it extends to these differences, but that they are universal in that they are, as long as you are human, so you can claim rights. It's almost linked to the issue of equality. But I'm not sure that it's about the different cultural aspects, because the different cultural aspects in many times go against rights. I mean, here you can talk about wearing color red, but what if in someone's culture, they're not allowed to speak? You know, women should not speak. Afghanistan women, girls should not go to school. It's cultural. You see, so I think universality is about the fact that as long as you are human, that is what gives you human rights. You don't need any other qualification. That has been my understanding so far.
Yeah, thank you very much. And I think that to a certain extent, it highlights what we want to, what we've been saying. And my colleague has wants to buttress the point.
Yeah, I just wanted to welcome that point in saying, as we are talking about how we're imposing the universality of human rights, there is also an aspect of the enjoyment of rights, which everybody is entitled to in whatever circumstance. And
Can't quite hear, please.
I was saying, while we are talking about the universality of human rights, there is also the aspect of the enjoyment, which everyone is entitled to by virtue of being a human being. And the universality is actually linked to the other aspects of human rights are universal, they're inherent, they're inalienable, they are also indivisible and interlinked. So this aspect just helps us to bring to the fore the minimum benchmark, which within the different cultural or lived experiences, parliamentarians can use this proactively or diplomatically to equate differences in each context. But it is not meant to accommodate all the contestations, but to make a bold declaration that there shall be equality.
There was another hand.
Yeah, I was just going to flag the fact that maybe where this issue originated from the gentleman that raised the very first issue on this, perhaps was trying to bring on board the aspect of cultural relativism, which becomes very important, particularly for the African context. And maybe that has not been thought through in as far as these principles are concerned. Yes, there are those aspects of repealing laws and everything, but what about the different cultural contexts, and what does that mean for a document that wants to be a document for SADC, for example? So maybe that can be unpacked somewhere from the premise that cultural relativism, the different cultures, the different norms and everything else, at the end of the day, should not negate the very essence of a particular right, hence the universality of human rights. So maybe that's something that you can look at and see if it is already in here or needs to be amplified or needs to be taken on board.
A point noted. Thank you very much. If there are no other contributions on universality, and we've taken note of all the other contributions, then we can move to the next principle, which is the principle of human dignity. Where to begin in terms of human dignity? I think the concept of human dignity really speaks to the equal worth of us as human beings. And there are different approaches, different prescriptions or philosophical underpinnings of the principle of human dignity. But I think that more than anything else, it is grounded on the other principles that we have looked at: the principle of equality, the principle of non-discrimination, and to a very large extent, the principle of universality. But human dignity then speaks to the actual worth of a person. And therefore that in the making of the law, and I don't want to go into the text, like I stated, we're proceeding on the premise that members had occasion to read the text. So my explanation is really to amplify the principle. I think that the principle of human dignity is derived from the different international and regional treaties that most, if not all, SADC member states have signed and ratified. It speaks to the fact that there is an inherent nature of human worth, human value, and that human value and that human worth should be taken into account or to a certain extent reflected when laws are being made. Again, I'll keep making the point that in the process of making law, Parliament should ensure that they take into account the worth of the people they are making the law for. So human dignity is one of those aspects that speak to the principles of human rights and should be taken into account. Others have contested the principle of human dignity and say it may not, what does it actually mean? But it simply means you have worth, and as a human being, you have value. There are examples that are given in the text, and so we will invite comments from the floor with respect to the principle and concept of human dignity. I think we are agreed, and we can move to the next. Another principle is what is called a human rights-based approach. In its most basic terms, a human rights-based approach encompasses the principle of participation in decision making. Oh, I skipped. Five was that? Oh, minority rights. Oh, sorry. I think I may have skipped it in the slide as well. Yeah, but I can speak to it. So the principle of ensuring that minority rights are respected, protected, and to a large extent fulfilled comes from the fact that there are certain groups, certain people, to a certain extent, even communities that are marginalized, and they're in the minority within a specific state. And therefore that in ensuring that laws are being made for everyone, the rights of minority groups are respected, protected, and fulfilled. So there are different categories of minorities that have been recognized. We know that even from a demographic point of view, even if in a country women will form the majority from a demographic point of view, but they're still a minority when it comes to when it comes to human rights enjoyment, children, persons with disabilities, and again, we included their sexual and gender minorities, there are persons living with HIV. There are different minority groups. And historically, these groups have been marginalized, have been discriminated, and laws have not been made in a way that takes into account their lived experiences and their concerns. So really the core with respect to minority rights is that when laws are being passed, parliaments should take into account the rights of these minorities, but also that parliaments should be more proactive. And this speaks to the aspect of positive discrimination, that where previously marginalized groups or minority groups have not enjoyed their rights, laws should be made or laws should be designed in a way that brings them from the margin and ensures that they enjoy their rights in the same measure as other citizens. It also means that traditionally discriminatory laws should be repealed. Parliaments should take into account the fact that there are certain existing laws whose effect on the ground causes discrimination and other forms of human rights violations for marginalized or rather minority groups. And therefore, this principle speaks to those pragmatic steps that parliaments should take with respect to minority groups and in the respect of minority rights. It also comes from a principle of democracy that is recognized within SADC and within the AU from the Charter on Democracy and Good Governance, that whereas democracy is the rule of the majority, the minority should be respected in terms of rights. So, any contributions with respect to minority rights? I see no, only one.
Just a minor one. Throughout these principles, somewhere we have to cite the sources by way of footnote, like this one, so that it may not be difficult for those who will be implementing the guidelines. the parliamentarian.
Excuse me, may we speak up a bit?
Okay, sorry,
Looks
sorry.
like we are all on low energy.
Yes, I was saying we may have to cite the sources where we get all this information. I mean, we are citing the principles, but we don't provide the footnotes like this one, so that the parliamentarians should not start now going into Google, trying to search where is this right, the minority, whatever. But I also repeat the previous comments I made with regard to this section. And I heard the facilitator, you're talking about SADC instruments. They are not making reference to this, the terminology I said earlier. Thank you.
Very well noted. Thank you very much. Any other? Any other contribution? With respect to the sources, one of the things that we did with the principles and guidelines was to provide annexures where the specific and different sources are found with specific websites. So if you look at Annexure D, it contains the core human rights treaties, and also Annexure E, the core international human rights treaties. It also contains what are called general comments, which are really a very elaborate explanatory note on what is called the normative content of the principles that we have talked about. We didn't want to create a textbook for parliamentarians as if they are law students. So we just wanted to state the principle and then provide the material, supplementary material in the annexures. Otherwise, it would be very difficult to follow if you state the principle and then you go into the philosophical explanation and all the legal explanations that go into it. Again, we buttress the point that we wanted to state the principle as it is known, and then the supplementary reading is provided in the annexures. I don't know whether that's helpful. I see a hand there.
Yeah, thank you, Mr. Moderator. I might appear maybe rather irrelevant at this stage in as far as reference to issues of international human rights law. One, of course, I do understand that this is now at our regional level. And hopefully with all these principles, that is that of universality, human dignity and minority rights, perhaps once our parliaments have really grappled with these issues, that it will also be taken forward in our various fora, for example, the IPU, as well as the UN through our various governments, or also IPU with our various delegations to the IPU on these issues, because one is always concerned about the lack of support or cooperation when it comes to issues of this nature, be it international or otherwise. A good example is that of the Rohingya refugees in Myanmar. In this day and age, people are being extinguished on the basis of issues of minority rights as well as religious or cultural rights. And the whole world is just looking on and doing nothing about it. So I'm merely saying that perhaps once we more or less adopt these principles, then we should really cascade them at the international level at IPU as well as UN. But I must say that I always raise this at various issues about certain issues that clearly the world looks away when people are being extinguished in this day and age. Thank you.
Thank you very much. That's a very important contribution. And I think that we should take it into account in terms of how we escalate some of the principles that we are making. Is there any other contribution with respect to minority rights from the floor? If there is none, then we can get back to, I think we're looking at the human rights-based approach. I think that the text explains it very well. And really what the human rights-based approach speaks to a very large extent is the issue of participation of people, the issue of consent of the people. So to a certain extent, it speaks to another principle that we'll look at a bit later, which is people participation in the governance of their country. But also human rights-based approach speaks to when laws are being designed, they should be designed in such a way that it ensures that the primary end users or the people that the law will affect take part in whatever processes are there. So we give an example there of investment laws because that is where the human rights-based approach discourse has really been enriched. For example, when there is an investment and an investment is being put in a specific area, we're calling upon members of parliament to ensure that in allowing laws to be made that investments can be put in place in specific places, the people whom those types of investment will affect play a role. For example, that they give consent to that development taking place, and that consent should be informed, and that when they are affected, they should be provided with adequate remedies. This is one of the issues that occurs in especially with respect to the extractive industries. So we thought that it is important to ensure that there is a human rights-based approach that should be taken into account in the design of different types of legislation. So any concerns with respect to a human rights-based approach? I see one hand.
Thank you, moderator. I would say that the human rights approach goes well beyond the issue of consent, largely because sometimes consent, sometimes parliaments and governments seek consent from people who really cannot give it. They're just too weak or uninformed position to give consent. So the human rights approach, I think when we're talking to parliaments, should be about when parliament is debating laws, is debating the budget, is debating distribution of a country's resources, it should be for the good of the right holders. So all parliamentary work, and especially I think when it comes to social and economic rights. So I've noticed reading through this whole document that there's very little address of the issue of social and economic rights. And I think the right-based approach is centered around social and economic rights. So for example, when a law is passed, we must take into account that the rights to education, the rights to water, the rights to health are taken care of. And that's about the parliamentarians themselves, even before we go to the question of consent. Because if we just make it about consent, it means members of parliament can get away with extracting consent that is harmful to people because maybe they just do not even understand a technical issue. Thank you.
Thank you very much. Duly noted. I think that another aspect of a human rights-based approach will be covered when we are looking at people's participation. The focus here was really to look at the different perimeters of what the approach speaks to, that the principle of participation, the principle of informed consent, accountability, the principle of a remedy, and so on, that those should be taken into account into the law. And I think that we'll also take into account the contribution that has been made and maybe enrich the content further. Any other proposition with respect to the human rights-based approach as a principle? Then we'll proceed to the next one, which is effective citizen participation. Yesterday, I think that when we were looking at the guidelines on corruption, this was one of the shortest. I hope it will be the same. It really just speaks to the fact that citizens should be able to take part in the governance of their country. And as a rule of thumb, whenever a decision is being made to a large extent, people should take part freely in such decisions in different ways, in different aspects, and in different forms. So we use the word effective because previously we used to say citizen participation, but that is not enough. Effective citizen participation means that the participation of citizens will have a level of impact on the ground. Views are welcome. If none, then we.
So maybe you have to cross-check, yeah, with the relevant international agreements, how this right is captured. Because the way it is, something is not correct. Let's say every citizen has the right to participate freely in the government. There are several international instances, so you have to cross-check how they read and recraft this one. Because this one may mean that everyone has to be in the government. The way we are capturing, that's not how it is captured.
Noted.
Thank you.
Thank you very much.
Sorry, just a minor on the previous paragraph, before paragraph 7, where we are talking about all arms of government. I think we can stick with the government. We delete this reference to all arms.
Yeah, that's also very duly noted. Thank you. I saw no other hands, so maybe we can we can proceed to the guidelines. So far, we've been looking at the principles. And like I said, the principles are sort of philosophical concepts that should guide the legislative making process. They're, to a certain extent, general, they're by and large universal. And this
Moderator, I
part,
think we've skipped one,
which one?
number 8. Political and social participation of an independent civil society.
Have we gotten there? Let me just cross check. On what page are you, Laura?
Under effective participation, there is an 8, which says political and social participation. 14 of 38.
Effective social. Okay, yeah, I was going to cover it in another aspect, but we can speak to it now if you desire as a principle, which is political and social participation. Part of the reason was we were talking about citizen participation, but as a principle for the respect and protection of human rights, one of the things we recognize is that civil society plays a very important and key role in ensuring that human rights are, to use the term, enjoyed, and therefore that laws should be designed in such a way that there should not be a shrinkage in the civil society space, but that civil society should be robust. Civil society should be able to push its agenda, its human rights promotion and protection work without being stifled. And this also comes from the recognition that there's been a conversation in the past years that the civil society space has been shrinking. And therefore, this principle really speaks to this fact that civil society participation should be enhanced. Yes, sir.
Merci beaucoup de m'avoir donné la parole. Il me semble que l'usage du terme gouvernement ici, même si c'est en anglais ou en français d'ailleurs, c'est pareil, prête à confusion. On sait très bien le terme juridique gouvernement, c'est le pouvoir exécutif. La version française prête à confusion, et moi je pense aussi même la version anglaise. Quand on dit chaque citoyen a le droit de participer librement au gouvernement de son pays, on sait très bien que le gouvernement, c'est le pouvoir exécutif. Moi, je propose, pour éviter toute confusion du terme, parce qu'on entend cela au sens juridique, participation à la vie publique de son pays, au lieu de gouvernement, parce que ça se répète à plusieurs reprises. Dans la deuxième phrase, et dans... Oui, deuxième phrase, les parlements doivent veiller à ce que les citoyens aient des chances raisonnables de participer efficacement au gouvernement de leur pays. C'est comme si le Parlement va donc forcer le gouvernement à accepter la société, la participation, on va dire, l'implication directe de la société civile. La société civile n'a pas de vocation politique a priori. Donc, il faudrait modifier ce terme pour que ça ne prête pas à confusion. Merci beaucoup.
Duly noted. I think that we'll take that into account. Yes, sir.
Thank you. Mine is a minor one.
I can see the word which is used for the civil societies is to participate in the process of making legislations. I understand most of the constitutions give that mandate to the members of parliament. To me, I would be comfortable if the word used is to be involved in the process, not to participate. Thank you.
I think we'll take that into account. We've been using the words participate because that is the normative language. So, but we take into account the fact that there are concerns with respect to the language. So we also didn't want to be inconsistent with the language that our states have actually adopted and understand. So we'll try to strike a balance, but participate is in this sense a procedural word that simply means that, for example, when laws are being made, civil society is called upon to make contributions, and that is participation in a way. So, but we take into account the fact that there may be need for more clarity in terms of using the language, and so I'm happy that I saw people nodding, so that's a very good sign. Thank you very much. I see another hand.
I'm thinking that a principle that has been left out, connected to what I'd said earlier, is the principle of the indivisibility and interdependence of rights. So that, again, focusing on the social and economic rights, which I think are the most abrogated in most SADC countries, so that you find that citizens of many of our countries, maybe especially the one I come from, Zambia, live well beyond, well below the standard of living they would have if their resources were accountably managed. So I think if we include indivisibility and interdependence, it puts the stress that we should not only be focusing on the civil and political rights, which we talk about whether it's movement and that kind of thing and voting, and forgetting about the social and economic rights, that they are central to citizens and probably the most important rights for most people in our communities who probably don't care who the president is because he's of no impact to them. So I think it's about making sure that we focus on what matters to citizens, and it is those rights.
Duly noted. I think indivisibility, interdependency can be included, and an explanatory note made. Any other contributions? So if there are none, I think we can proceed. I'm being guided that it is tea time, so perhaps we can break for 10 minutes and get back after 10 minutes. So I think we can break for just 10 minutes for tea and get back after 10 minutes. Um, welcome back, ladies and gentlemen. Think we can take our seats. And get back to the program. So thank you very much. We get back to where we left off from. We were looking at the guidelines. We had just started. So we are looking at section 3 of the principles and guidelines, and we'll be looking at the first guidelines. The guidelines are really meant to be an approach that parliaments can take to ensure that the principles of human rights are taken into account in the role that parliamentarians and parliaments play with respect to human rights. Obviously, it's very difficult to be all-encompassing because guidelines can be broken down into 1,000, but we have tried to ensure that we condense the guidelines as much as possible into what we think can be done. So as a starting point, and this video also speaks to the general principles of democracy as a guide, is that ensuring the representative nature of parliament. And that is to say that members of parliament must be freely chosen by citizens of their country to represent them in free, regular elections. This really comes from the African Charter. It comes from the Charter on Democracy, Elections and Governance. And the point here is to speak to the fact that parliamentarians are representatives of the people, and therefore that the people are the primary power holders, they are the mandate givers. And in so giving that mandate, recognizing that they are representatives of the people, the synergy between the people and the parliament and parliamentarians should not be lost. And therefore, in ensuring that human rights are respected and protected is really coming from the ground that the mandate givers hold rights, which are expected to be enjoyed through the facilitation of law reform, lawmaking, and law repeal by parliamentarians. So the starting point really to having parliaments play an effective role in ensuring human rights is to ensure that parliaments are actually representatives and that people actually choose. So this is like a ground guiding principle. Yeah, and it's a principle that, as I said, steeped in democracy. It's almost a given, but I think that it's also important to state as a starting point in looking at the guidelines. So if there are any concerns, I think we can take them. I see a hand.
Yes, thank you. Maybe the title is talking about a representative nature of parliaments. The first paragraph is talking about members of parliament must be freely chosen by citizens. But the second paragraph is talking about electoral conduct of elections, local and regional observers are not restricted. So it means that we can expand the title and these two paragraphs to incorporate other elections like presidential elections. We are talking about counties elections, counties elections, and the other elections. We should not be restricted to parliamentary elections. So it should be the role of parliaments to ensure that leaders, we are talking about leaders or governments, people who are chosen to the governments are freely chosen by citizens. Because now it is only restricted to parliamentary elections, which is not true, which is not correctly the case. There are other elections. We have to cater for all of them. Thank you.
Okay, that is duly noted. There is the proposal that there should be an addition of other types of elections. So I think we can take that into account. The point of this guideline is that when, for example, electoral laws are being amended or are being made, they should ensure that those electoral laws are such that the mandate that is given to Parliament is actualized by the people. For example, election observers must be allowed. That is one way of ensuring that there is actual representation from the people to avoid having elections that are not fair. So to speak, to ensure that elections are free and fair is one of the ways in which you ensure a representative parliament that is also legitimate. But we take the point that presidential elections can also be included. But I think that we'll do that as an explanatory note to ensure that it is governance is encompassed. Any other concern with respect to this guiding principle of the representative nature of parliaments? Could you open that? Okay, if there are none, I think that it will be safe to proceed. And that is guaranteeing the sovereignty of Parliament by protecting the freedom of expression of its members. This comes from the fact that members of Parliament are members, and that the law should ensure that in their conduct, in the way they seek to represent the people that they represent, they do so without being stifled and without being prevented from speaking. So these points speak to the fact that members of Parliament have got freedom of information, and therefore that members should be free to seek, receive, and impart information and ideas without fear of reprisal. Members of Parliament must be given independence, and the law should bestow on them parliamentary privileges and immunities. By this, we do not mean that members of Parliament should just go up and about without any form of restriction, but really that, for example, in the House, in expressing the manifest will of their people, they should be able to do so without fear. We also take regard the different complexities and types of parliaments that exist within the region, but that those types should not be in such a way that parliamentarians are stifled from expressing the will of the people that they represent.
Yes, thank you again. Maybe the way this paragraph is couched is different from the first principle. Is it a guideline here? Because I'm going back to section 1 here. Parliament must ensure that in the conduct of elections, international observers are not restricted. So if you come to the second one, it says, it's like a right now. It's like we are setting a principle. We are not offering a guideline on what should the parliaments do with this respect. So the focus, you find a way of capturing. Even the last sentence members of parliament must be given independence. So the focus should be the parliament should ensure that the laws, procedures, processes.
Yes.
Yes, allow for that independence. Thank you. Thank you.
Yeah, very well noted, and thank you very much. I think that's a valuable addition to the document. Any other additions, concerns, statements? Okay, so we'll proceed to another guideline. And this guideline speaks to constitutional and human rights literacy. It talks about investing in knowledge and continuous capacity building. It's grounded on the fact that we know that not everyone comes from the background of knowledge and understanding of human rights. And therefore, the guide is that members of parliament must have knowledge of the constitution, how governments function, parliamentary procedure, and the state's human rights obligations. Members of parliament must be up to date with international standards, best practices, and development relating to human rights, and should be knowledgeable about required legal and justice sector reforms. So this really speaks to capacity building, knowledge building of members of parliament, because if we are going to expect that parliamentarians are going to take into account human rights principles, they must have knowledge of those human rights principles and on a continuous basis, because the human rights discourse is continuously evolving. And also the parliament of today is not the parliament of tomorrow. So the guide is to have to ensure that human parliamentarians are continuously capacitated with human rights knowledge. One way of doing this, for example, is to have research materials at parliament buildings to ensure that there are sufficient orientation programs when new members of parliament are being initiated into the house, so that they are aware of the different human rights issues that permeate the legislative process. And there's continuous capacity building trainings inbuilt within within the houses of parliament. So that is sort of a guide for capacity building. Is there any concern? I see two hands. I'll start with.
Probably just to add a little bit. Sometimes parliaments do understand, or maybe they do know the international standards, but probably it may happen. In fact, we talked about the SOGIs a little beforehand. Maybe parliament should know what are the conventions, the treaties their countries have endorsed, so that they can and domesticated. Thank you.
Thank you. Good morning to everybody. In my case, I don't have any problem with the principle, but the problem I can see is that the summary of the guideline is not consistent with the contents of the guideline itself. Here we are talking about continuous capacity building of parliamentarians. But when you read the summary, it refers to member states. So I'm not sure if it was a slip of the hand. And if that is the case, then you need to recast it. Thank you.
Okay, we take note of the summary guideline on page 16, which says member states must have knowledge. It must read, members must have knowledge of the legal framework, parliamentary procedure, and international standards and best practices with respect to human rights.
Yeah, and perhaps it also takes into account what Phineas said, where we can elevate the language to be guiding and prescriptive as opposed to just being plain and neutral like a principle, so that there's a clear understanding of what we require parliaments and member states to capacitate parliamentarians on, as opposed to just state that they should be, knowledgeable.
Thank you. Any other contribution on investing in knowledge and continuous capacity building? Okay, so we can move to the ratification of treaties. And this is one of the core functions and duties of parliaments with respect to the protection and promotion of human rights. It's actually at the root of the human rights duties of parliaments. And that is to say that parliaments should, as much as possible, ratify the international treaties and regional treaties that speak to human rights, which the executive has signed. So it's very self-speaking. I won't get much into detail in terms of explaining what this duty means. I see a hand.
Does Parliament ratify? Because I thought number 5 is what deals with the domestication of regional international human rights would be Parliament, but ratifying is the executive, isn't it?
Ratification is, sorry.
Yeah, ratification is an executive act, but we're prescribing that parliaments should, be in the position to push for and to ensure that the ratification, not necessarily that parliament ratifies. So I think the language in the summary guidelines there is parliaments should ensure the ratification of all international and regional human rights treaties. Not
Okay.
should ratify.
Actually,
Was part of that, sorry.
actually, it is both the parliament and the executive, because you can't ratify an international treaty without taking it to the parliament. Because the parliament is a representativeness of the people. So they say that we agree. This is what we are saying in yesterday's guidelines. We are talking about approval. So they approve, and then the executive just communicates the stance of the country, of the state.
Yeah, exactly. And that is why we are borrowing from the use of the word ratification. We also take into account that different countries within the SADC have got different ratification procedures. So in most countries, you'll find that the act of ratification comes from parliaments, and then after ratification, then there's domestication. The argument that has been made is that if the executive ratify, then they're having lawmaking power, which doesn't belong to them. So there is a consistent move and drive for parliaments to actually ratify, and upon ratification to domesticate as another layer of ensuring that there's human rights protection. So hence the use of the word ratify. But I think in principle, we capture the essence unless it is felt that the essence is not captured.
Yes, it is, but maybe the second paragraph, it contains a lot of information that should be in the footnote. You can put them in the footnote where we are defining what is ratification, so that we stick to, because this is supposed to be a principle. So we have to say what the parliament should do. And as you have correctly said, we also have to reflect the issue of domestication. So the parliament should move for a ratification of international, continental, and regional instruments pertaining to human rights and ensure their domestication.
Yeah, duly noted. I think
Yes.
that's a valuable contribution. Any other? Okay, then we'll move to domestication. I think it's also very self-speaking. The ultimate test of human rights law is the extent to which it takes roots at national level and its ability to flourish in the soil of states and to bear fruits in the lives of people. I like that sentence. This is done through domestication. And that is to say, without domestication, it's very difficult to give people a lived experience of the international human rights principles and standards that a state has ratified. So this is really to call upon parliaments to domesticate international law, the international treaties that it is a party to. I don't imagine that this guideline would invite contestation. So I don't think that there are any issues or concerns with respect to domestication. I think the essence is captured. And if that is the case, then we'll continue. Is that a hand?
Sorry, maybe if I can get some clarity on two terms here. Parliament and the parliamentarians from your document. Is there any difference? Thank you.
By and large, they can be used interchangeably, but one of the things we're trying to do also is to try to personalize it so that as a parliamentarian, when you read it, you can say, okay, this speaks to my duty when I'm actually doing that vote, but also as a collective parliament. So it's just trying to be emphatic in the nature of the House, its collective nature, but also its individual nature. Because these duties are not only collectively held, they are held individually. When you receive a mandate from the people, you have a mandate to act in a specific way, and that specific way is in line with the mandate you have been given by the people. So just trying to personalize it also. I hope that is fine.
Yeah, I'm asking this question because I think from even the previous slides, so you're talking about that members of parliament should be capacitated. Parliament should make sure that, to me, there's like, yeah, if you're talking of parliament, you're talking of the administration. Which like maybe it should capacitate the members of parliament, maybe when they come to office. That's why my question was based on that. Thank you.
Oh, so you would prefer here that we use the term parliamentarians?
I think both, because
Both,
maybe there are certain issues where you need to have parliament to do something to the parliamentarians. Thank you.
I understand. I think that's a very important point. So parliament as an institution, but parliaments also as an arm of government with parliamentarians. I think that's a very important point. Another guideline is legislating human rights conscious and gender responsive laws. So I'll try to read from the text. And the primary role of parliaments and parliamentarians is to make laws. In performing these functions, parliaments and parliamentarians have the responsibility to ensure that proposed laws are responsive to the needs of both women and men, and that they do not violate the rights of citizens in the content and effect. One way in which this is done is to build a human rights conscious for them to establish and also for them to establish parliamentary human rights committees. Such committees should be given mandate to ensure that proposed legislation addresses the different needs of men and women, and that it is in line with the state's domestic and international human rights obligation. I can already see that perhaps we would need to enrich this by further guidelines, but I think what the essence of this is to ensure that when there is a sort of a human rights consciousness in the making of law, there is I don't know how to put it. There's a discourse that is developing that we should continuously be human rights conscious whenever we make laws. I see an intervention.
Thank you, Mr. Moderator. I am a bit disturbed with this paragraph. I know you are being gender conscious, but when you illustrate here, both men and women, we are leaving others behind. What about other citizens who's not a male, not a female, and children also? They are being left behind. Maybe we could correct this by putting proposed law are responsive to the needs of everybody, and this will cover everybody. In my point of view, I know you are being gender conscious, but if you put everybody, everybody would be covered. I don't want to go back to the debate of marginalized group. And by putting this, you single out only men and women. The others who are not men, not women, he or she, marginalized group, the transgender, they are left behind.
Yeah, thank you very much. I think we'll take that into account and we will refine the language. I think the point is duly noted and quite valid. Any other concern? I don't see any hands, so I think that we can move.
May I come in? But by doing so, I think maybe we should amend the last sentence by saying, do not violate the right of any citizen.
Very well noted. I think we'll take that into account. So we move to another guide. Also one of the important roles. We looked at the domestication of international human rights. Oh, sorry.
Go back to the legislation of human rights and laws.
I hope
Where-
everyone can hear.
Yeah, where does the migrants and their families comes in? We are talking about citizens. So maybe we should include a clause or a few words in relations to the migrants and their families as well. Thank you.
Thank you very much. I think it has consistently come out, and I think that's something that we need to expressly state in the guidelines, so that the obligations are not only to citizens but also to migrants and everyone. I think there is also a growing concern that that's not happening. So I think it's important that if these guidelines are to be progressive and transformative, we include that aspect as well. Okay, so we were on another aspect, and I was going to say that one of the roles of Parliament, one of the important ones that we talked about is domestication. But apart from domestication is actually the repeal of laws. We come from a history where certain laws were made which were very discriminatory, and those laws still sit on the statute books of our respective countries. Research shows that a lot of the colonial legacy laws that were discriminatory still sit on the statute books, even if they are not being implemented or being used, even if they are unknown. It is important that they should be taken off the statute books, they should be repealed. And also, therefore, this guideline speaks to ensure that these laws are repealed. If you see there is a guide that in trying to do so, parliaments should collaborate with civil society, academia, and human rights defenders who may be aware of some of these laws so that they can be repealed. Researchers will always point to specific laws that parliamentarians may or may not know, as the case may be. But that is a guiding principle, that motions should be moved to repeal these laws. So I think this is quite self-speaking unless there are any concerns with respect to it. Yeah. So if you look on your pages, there is a general the general guide to actions for conduct of parliament in the exercise of official functions. If you look at that, it really speaks to some of the things that we have talked about, and I think that unless there are issues that arise on that particular point, I would like to skip to section 3 in terms of implementing the guidelines. The specific guides there that you see are specific points that also give a bit of meat to what we have already spoken about. And again, we are proceeding on the assumption that members have read. So if you would permit me to move to the next section, unless there are concerns or questions that arise on that particular part, then we will be happy to address those concerns. I see a hand behind.
Thank you. I'm looking at this guideline, and I'm not sure whether it's assumed that the law reform commissions or institutions in our countries would be under the listed actors. You're referring to academia, civil society, human rights defenders, and communities. But I would want to believe that the law reform institutions in our countries should be very active in ensuring the repeal or the review or review amendment and repeal of these unfriendly or gender unresponsive laws. I don't know whether there's a need to include that, but I think it's very important that we ensure that the parliament has a say or is able to engage with the Law Reform Commission on such issues. Thank you.
Absolutely. I think that's very, very important. The collaboration between parliaments and law reform commissions or law reform departments is cardinal to the repeal agenda and repeal functions of parliament on friendly laws. So I think that we will include that. It may have been an oversight, but that's very, very important and a very pragmatic step that can be taken. So are there any issues with respect to this part? The guidelines explain the three, some of the three implementing guides: that prioritizing human rights implementation by parliaments, capacity building by parliaments, initial research. All these speak to some of the guidelines that we've already spoken about. And if there are concerns to be raised there, you can do so now. I see 2 hands.
Yeah, moderator, thank you very much. I just want to make sure whether we are together. Your section 3 is section 4 in our documents.
Yes, yes. Yes,
Oh, okay.
yeah.
It's the same one.
Yes,
Thank you.
It's the same one, yeah. Yes, sir, go ahead.
D'accord. Ce qui me préoccupe, c'est disons, la légèreté avec laquelle nos parlementaires étudient et ratifient les traités internationaux en général, y compris donc les traités relatifs aux droits humains. Je ne sais pas qu'est-ce qui se passe dans d'autres pays, mais chez nous, on a cette impression, puisque les pouvoirs des parlementaires sont limités dans le cadre des études des traités internationaux. Ils ne peuvent pas amender le contenu de ces traités internationaux, ce qui fait qu'ils l'adoptent généralement sans étudier en détail, sans mesurer les conséquences de l'adoption de ces traités internationaux au niveau de l'Assemblée nationale et dans l'ordonnancement juridique du pays. Il y a beaucoup d'exemples par rapport à ça. Par exemple, nous venons de ratifier l'année dernière la Charte culturelle africaine, qui dans son article 9 réitère que désormais l'enseignement de l'histoire dans notre pays d'Afrique doit se baser sur l'histoire générale de l'Afrique, qui est une œuvre colossale de 9 volumes rédigée par des grands historiens africains multinationaux. Après l'adoption de cette charte, je ne vois pas, disons, les directives ou un plan d'action au niveau du ministère de l'Éducation nationale dans le cadre de la mise en œuvre de cette disposition. Et c'est la même chose pour les autres dispositions. Donc, comment faire en sorte que même au niveau de son examen, au niveau du Parlement, les parlementaires négligent un peu la valeur et l'importance de ces traités internationaux. Comment s'assurer qu'ils vont devoir après être soucieux de leur mise en œuvre au plan national. Donc, ce que je demande, c'est plutôt des suggestions, parce que nous, au niveau de l'administration, à travers des notes, des papiers, on ne cesse de rappeler le contenu réel de ces différents traités internationaux, mais ils n'ont pas cette culture d'analyse et disons, de lecture de façon profonde de ces traités internationaux. Ils ne mesurent pas toujours leur dimension sur le plan national. Je vous remercie.
I think that's a very duly noted contribution. I think it's more of a comment and a contribution to the House. I think that's one that we need to take into account. It really speaks to the culture of different parliaments, but also to a certain extent, the different systems that different countries have in terms of domestication. And I echo the sentiment that parliaments do not have the power to amend treaties, but that in domesticating them, they should, as far as possible, try to reflect the normative content of a treaty. I saw a hand.
Thank you, moderator. Maybe from mine is on the previous slide, which talks about the repeal.
I don't think they're able to hear you.
The previous slide that talks about repeal. Yeah, I think that one, yeah. And maybe my concern can be if there an interpretation from the document, if you talk about law, what is law in this document? Because I think there's a previous speaker.
Are we able to hear?
There's a previous speaker which talked about cultural laws in terms of being seen or being seen to be demonized by these human rights charters. That's why I'm saying if now we are taking back these to member states to say repeal those laws, maybe. I think if maybe we can look at another word as to repeal, it seems like it's coming like an order to change. Maybe those, if maybe that law includes even like customary laws, maybe like an example. Thank you.
What would you propose? What word comes to mind?
Maybe it can be consider.
Hmm.
Yeah, I think I get exactly where you're coming from. What I wanted to do is situate these prescriptions or guidelines in the constituency of the already prevailing debates. Someone spoke about plural legal systems. They're an immediate response to the concern around cultural relativism, where it was realized that the formalist sense of law is not always essential in delivering justice. So there are circumstances where I am used to the Zimbabwean legal system. They will have a dual legal system where even in court, depending on your upbringing and your beliefs and cultural exposure, they can apply a different formula in inheritance in divorce proceedings. And I think that those nuances are already taken care of in the different legal systems of each country. If there's a cultural issue, I think those kind of plural or dual legal system considerations have already taken care of the fact that there won't be an ultimate repeal of any culturally sensitive issues because they are already being dealt with in that context. So you have the courts of the chiefs, you have the small claims courts, you've got the magistrates courts, and that contestation, I think, is already within the balance that has been achieved. I don't know if it will be worth it for us here to restate that tension, or perhaps we should just be saying, even in the context of the plural legal system or of the formal legal system, any aspects that seem to present challenges for the enjoyment of rights by others must then be dealt with in terms of maybe law reform or repeal. I think that's the context. I'm not sure if that provides a certain different level of perception.
Yeah, I think it addresses the problem. I think the other one that you mentioned, instead of repeal, the other one, I think it suits very well. Instead of just, if you say repeal, it's like, you've just seen it, that seemingly this law is incongruent with the universal of human rights. Thank you.
I think I understand the point, but also it's important to borrow parliamentary language itself. And one word I know they like to use is to repeal. It's one of the functions that is, one of the manifest functions of parliament. So we try not to run away from the word repeal, but I think that we can say repeal and reform. Maybe that will capture it. I see two hands, 1 and 2.
Thank you very much. Yeah, I think we can do, in my opinion, I think we can still do with the word repeal because from my understanding as a lawmaker, we've got 3 main functions. That is to make laws, repeal and amend. And then the oversight comes in as the 4th. So using the word repeal, I think it's very in order and parliamentary as well. If we change it, it is going to dilute the powers of parliament. I submit. Thank you.
Exactly. Thank you very much. I see another hand. Yes.
Yes, thank you. From a legislative drafting point of view, lawmaking includes all the others like enactment, repeal, reform, amendment. So, but for purposes of clarity, I think we should just leave the repeal there, even though all of them are subsumed under lawmaking.
I think there is consensus in the House. Yeah, they're just guidelines in any case. Yeah. No, I think we are guided. Thank you very much. Then we can just, I'm also alive to the fact that we need to be at a certain point in the program by 1. So if you permit me to move to this aspect of the guidelines that speaks to specific recommendations for regional stakeholder engagement and advocacy, I'll try to be quick in running through these because the meat of the presentation was really the guidelines and principles. And once those are agreed, some of the nitty-gritties or actualization mechanisms can always be amended. So, but I just thought that it would be good to have a conversation about some of these aspects. And I'll just run through them standard by standard or recommendation by recommendation. And if there's a concern, maybe it can be raised on each without going into details of explaining. So one of the specific recommendation is non-state actor engagement platform on implementation of human rights standards, which really speaks to engagement of non-state actors in the actualization of the principles. Any concern on that? Any additions, subtractions? Yeah, I think we can move to routine human rights missions, which really speaks to enhancing the capacity of SADC-PF to conduct visits at national parliamentary level and engage with member states to see how they are actualizing the principles and also just how they are promoting human rights. And the other one on the page is highlight the importance of business and human rights. I think this is one thing that has been coming to the fore in the sense that there is a relationship between business and human rights. And I think that has to be highlighted in terms of the engagement, especially the engagement with non-state actors who do not think that they have human rights responsibilities. Again, I'm proceeding on the assumption that we know where we're coming from because we read the principles. So I'm really running through with that assumption. Okay, I'll move to the next page, which talks about design of national human rights protection programs by parliaments. And here one recommendation is to have focal point persons to carry out the agenda and to ensure that there is a compilation of reports and also a collaboration with civil society. For example, these activities can be aligned with monitoring of the state reporting mechanism under the African peer review mechanism and the universal peer review mechanism. I hope we are together. I have a feeling that, are we together? Thank you very much. My teacher always used to say, are we together? And if we're silent, then he would go back and start teaching again. And I'm also a lecturer at a university, so I always ensure I ask my students, are we together? If there is silence, I start again. So are we together? Thank you very much. Drafting of code of conduct of parliamentarians and pledge of allegiance. I think that this keeps permeating through a lot of guidelines. And I think that whereas it exists, I think one of the things that this should speak to is to continuously ensure that guidelines and codes of conduct meet specific evolving demands. Any contributions, any thoughts, concerns on the two recommendations? Okay, we proceed. Raise awareness of parliamentarians under SADC-PF as duty bearers under international human rights. This really also speaks to another recommendation that we made, that there has to be continuous education or continuous capacity building, but also to just inculcate it in the minds of parliamentarians that they are duty bearers or they have a responsibility to ensure human rights are protected and promoted within their states. Second, enhance awareness of the quasi-judicial character of Parliament in implementing the law. Then duty of good faith, because Parliaments legislate in circumstances where principles of separation of powers have been limited. It is critical to exercise its function in good faith. This really speaks to the fact that in making laws that are human rights responsive and human rights friendly, they are done so in good faith, because Parliament is one arm of government, the executive is another. But sometimes you have situations where laws are made to sort of cripple the executive, but that is not the idea. In short, not to politicize the discourse of human rights for the advantage of one arm to the disadvantage of another, but just to ensure that the focus is on people and within the jurisdiction. I'll take it that the silence means that we accept the recommendations.
Chair.
Yes.
I fail to understand the second paragraph, enhance awareness of the quasi-judicial character of Parliament. I don't think I've ever come across this concept regarding Parliament having a quasi-judicial character. And I don't know for the other parliaments, but Parliament doesn't implement laws. It's quite foreign to merge.
All right, thank you. I actually was thinking the same thing and I wanted to expand on it. But I think there are circumstances in which Parliament sits as a court, and there's some form of immunity that parliamentarians are given when they do certain things which the court can't even intervene. And then this is premised on the aspect of judicial difference or deference, whereby it just recognizes the huge responsibility that parliamentarians carry when they legislate. There are many instances in which courts can intervene in the implementation and interpretation of the laws you make, but there are also some very grave critical instances where courts don't have the capacity to do that. So for example, socioeconomic rights. If the parliamentarians sit, research, and think long and hard about how to allocate resources so that there's progressive realization of certain socioeconomic rights like health, access to education, in the end, once they make that decision, courts cannot revisit the particularities and complexities of sharing resources in the particular circumstances of the budget and the state, because these are things that only Parliament really understands. So you find that there are official circumstances where judges actually then defer, where courts defer to the discretion of Parliament, and what Parliament legislates becomes final. And for technical and practical purposes, not appealable in court. and courts will say, we respect the decision of parliament, and anyone who's trying to legislate, to challenge this legislation, we will not have a leg to stand on, and we will not entertain this. We will implement how parliament prescribes it. So this is something that I think is very essential for parliamentarians to know in certain complex situations, that you carry a final say in how the law is made, but also implemented and interpreted.
Yes, well, I can't really find concur with what you're saying, really, having been in parliament for so long. But maybe you can say that in some parliaments, I don't know. But sincerely, it's quite, it doesn't espouse our system.
I think therefore that is taken because we don't want to subject a basic principle which is not applicable to your system. So we should make it an option for those who can apply it to apply it, and we will capture that in the language.
Any other? I think I saw one. Was that a hand? No. Okay, is it in good order that we move? I'll take that as a yes. So another recommendation is strengthen coordination and relationships between the African Union and regional economic communities. There is need to create synergies between the different regional and sub-regional organizations to ensure that there is human rights protection and promotion in a complementary manner. I think that we have shared responsibilities and this principle recommendation really speaks to those shared responsibilities and duties. And also it's premised on the issue of extraterritorial responsibilities and duties that states have. Another is to promote constitutionalism and democratic governance.
Sorry, just a minor one, just a matter of focus, yeah? The previous one, because we are talking about SADC region, so we do away with REX. And in the title, in the first paragraph, strengthening coordination, we start with between the SADC region, for example, and the African Union. The text also. So we do away with other regs. They are none of our business. The ECOWAS and thank you. Unless we are saying strengthening cooperation or coordination between SADC and the AU and the other regs.
I think that would be a good way of putting it. I think it will be recast. But just to capture the complementarity principle and cooperation with regs, and also to ensure that we can borrow from each other's jurisprudence is quite important. Yes, sir.
A minor one, I heard you talk about synergies. There is symmetry. Maybe my English is supposed to be synergies. Eh?
Yes, I saw it. Even as I was reading, I looked at it and then I decided to jump it. I didn't want to say that we're trying to bury these organizations, so it's not symmetry. But thank you for the observation and pointing it out. Any other? So here we are also looking at promoting constitutionalism and democratic governance and recognize the African Charter on Democracy and Governance as a human rights instrument. Most often it is recognized as simply a political instrument and that it does not play a role in the actualization of human rights. But when you read that document, it really points to the fact that its domestication, or at least taking into account its content, will have a positive impact in terms of the human rights lived experiences of people within the SADC member states that would take it into account. So if we are agreed on this principle, I see a hand. Is that a hand? No. If we are agreed on this principle, we can then move to the last one, which is Regional Parliament Alliance on Human Rights Promotion. A specific platform can also be mounted to consider the capacity of various parliaments at regional level to promote implementation of human rights standards. The cross-pollination of best practices can also be facilitated.
Yes,
see a hand.
am I known again, that regional parliaments, can't we say member states parliaments or things like that?
I think for clarity, that
Yeah,
is,
for clarity, yeah.
that can be taken. So for clarity, that we'll take that into account. We are doing quite well with time, I think. And in terms of the substance of the guidelines and principles, I think this is where we can end. If you look at the document, it contains annexures. We also tried to make it simple. Yesterday, we talked about having a sort of a pager for someone to just look at. And so what we did was we summarized the principles. So we have summary principles and guidelines. We have, and then we have model of Parliamentary Human Rights Committee. It's an annexure. It comes from the UN, and we did a mapping that most SADC members, all SADC member states have actually adopted it. And then we also have an annexure of the core human rights treaties and some other resources that parliamentarians can use to understand some of the content in the guidelines. So we have all the treaties there. We have the sources of those treaties where they can be obtained. So a soft copy of the document will lead the reader to the source of these international instruments, international treaties, the conventions, and including the model Parliamentary Human Rights Committee. Of course, the complexion takes different shapes, and that is not a prescription that can be made. So, ladies and gentlemen, unless there are issues that are felt to have been left out, or issues that can be pointed out to enrich the document, they are welcome. Otherwise, that is the end of the presentation of the principles and guidelines today. And I wish to thank you for your participation. Thank you very much. So it seems that we have finished on time, and I will be guided by Croatia on the next step.
Thank you very much, Landy and Stanley. I think you did a wonderful job in taking us through the knowledge tool and also in saving time. I think we can give them a second round of applause. At this juncture, I think all is well that ends well. And in that regard, we wish to move towards conclusion of our meeting. And I wish to invite Madam SG to deliver a few words as we close our two-day meeting. And I will make further announcements to guide what remains as part of our program before we leave the room. Thank you very much. Over to you, ma'am.
Thank you very much, colleagues. Maybe just stand a little bit and stretch. It's been a heavy session. It's been a heavy session. I guess we are owed certain rights. Yeah. Just so that we lighten up. I don't know what normally happens. I don't know if you ever sing. And Africa will be saved. Do you know that song? I'm not a singer, so I don't know. How does that song start? Believe and I believe, and Africa will. Agnes, you seem to know what you're doing. And I believe, then Africa will be saved. The Holy Spirit shall come down, and Africa will be. Thank you very much. It helps sometimes to lighten up. Thank you for your cooperation. Director of Ceremonies, dear colleagues, allow me to stand on the protocol that was established yesterday. I hope that will be allowed. And allow me just to say, dear colleagues and distinguished participants, on behalf of the SADC Parliamentary Forum, and on my behalf, I wish to thank you for your active participation. I wish to thank you for taking time out of your schedule to be with us today and yesterday. Without a doubt, we have been further enriched by the deliberations and the interventions that have been made by yourselves, both by sharing your knowledge and by sharing your experiences from your respective countries. As Nelson Mandela rightly said, and I quote, "To deny people of their human rights is to challenge their very humanity." Indeed, a democracy cannot prevail without human rights. It cannot prevail without human dignity of individuals, as well as collective groups. It is with this perspective in mind that we must continue to move forward together in dealing with some of these instruments that would advance our people's well-being. I think we have come a long way with distilling reflections from these two knowledge tools. The guiding principles have allowed us to reflect further, and I believe towards curbing corruption and taking us further to the promotion of human rights by national parliaments. Your comments have been duly taken on board by our presenters, who are also our facilitators by the SADC Parliamentary Forum. And following the deliberations today, we're also cognizant that there is much progress to be accomplished in implementing human rights and curbing corruption, especially when we look at the issue of human rights. It became quite evident that socio-economic human rights, which are normally enshrined in national constitutions or the Bill of Rights, are quite critical in our work and in also ensuring that Parliament's capacity to distill these becomes even much more critical. We are also confident that the 8 principles, and I'm happy they remained 8, I'm not sure if they will expand, but the appetite to keep them at 8 will facilitate the pathway to implement all human rights without distinction as envisaged by the Banjul Charter. We are also appreciative of the fact that the implementation of human rights and the Sustainable Development Goals should be looked upon as complementary initiatives instead of separate projects as they are closely linked. Going forward from this meeting, I invite you to consult the validation version of the principles and guidelines, which will be processed by the technical working group in the next 2 days. The validation version of these tools will be circulated to your parliaments and your respective ministries. And as agreed, we are hoping to get your feedback by the 6th of March, 2023. I wish to reiterate my gratitude for your participation and hope that we'll continue in this spirit going forward. Thank you for your kind listening.
Thank you very much, Madam SG, for the kind words, and I wish to inform honorable members and participants regarding the next exercise we are going to be doing. It won't be too long, but it is a necessary exercise. The tools we considered yesterday and today were developed as part of a project which we are undertaking with funding from Austrian development agents through GIZ. There are many other activities related, that are embedded within the project. And we are currently doing an evaluation of that project. So because of that, we would like to request the following category of persons to remain behind as we go for lunch. But maybe before we do that, I wanted to confer with colleagues from admin if there are any administrative announcements that we may need to share with colleagues that may fall outside the category of persons I'm going to announce. Are there any announcements, specific announcements? I do know that some of the participants that will be leaving tomorrow will be curious just to touch base and get final advice on any matters related to their travel. Maybe while we are waiting for that, to the extent that we all have been exposed to the tools, I may as well just give a brief on the project so that everyone is briefed. And then when we remain with the category of persons I mentioned, they would have been informed already. In any event, as I said, the tools were developed under the project. Who knows, we might still be able to reach out to some of those who are attending this activity, an activity under the project for the first time. With that understanding, and through your indulgence, Madam SG, I want to quickly run through, is Dr. Chikojo in the room? May we beg his indulgence to come into the room? Because he's the consultant and he would need to be following when we are doing the presentation. Before I forget, I'm being reminded that those who haven't submitted their boarding passes must do so to our colleagues from admin. Please do that as we leave the room. Dr. Chikojo, I'm going to take the next 3 minutes just to introduce the project to the participants. One of the things that is clear is that because the tools were also developed under the project, we might be able to reach out to some of the persons who are not clerks of parliament, who are not members of parliament, particularly chairpersons of standing committees and those from civil society organizations. So let me just give the brief to everyone, just in case you decide to also target those that are coming from the anti-corruption agencies, the human rights commissions, and the investigative units and the prosecution authorities who are in the room. So in brief, this project is funded, as I said, by Austrian development agents and GIZ, and it's titled Strengthening Parliamentary Capacity in Southern Africa Development Community. And it's been running since 2019 to December 2002 initially, and extended for 2 months up to February 2023, not 2022. And so the project had 5 objectives. The first one on strengthening the SADC-PF's role in enhancing the role of women in regional integration agenda, where we have undertaken a region-wide study on the challenges that women face in political participation. We have organized a regional dialogue on the issues of women political participation and the strategies to enhance that against the reality of stagnating or declining numbers of women in through electoral processes. Then the second objective is SADC-PF's role in promoting democratization processes, accountability, accountable governance and human rights is further consolidated. This is where we're dealing with issues of human rights, corruption that we have been dealing with over the last 2 days. But those who are members of parliament from SADC-PF would know that we've undertaken a number of other activities which are aimed at building the capacity of parliamentarians in promoting and protecting human rights and also in curbing corruption. We have developed these knowledge tools and also enhanced collaboration between SADC-PF, national parliaments, SADC-PF, and human rights and corruption institutions at regional and national level. We have also, under this objective, been supporting the transformation process of the SADC Parliamentary Forum. And as I indicated in the introduction about SADC-PF yesterday, the Summit of Heads of States of SADC has approved the transformation of SADC-PF to become the SADC Parliament. It was part of that process. It was getting a part of its support from the project. Then there is objective 3, the capacity in program management and parliamentary coordination of SADC-PF being strengthened. This was looking at benchmarking and coordinating with other regional parliaments, the Pan-African Parliament. Then the popularization and domestication of model laws and SADC protocols. We specifically the model law on elections, because as you may be aware, following the revision of the SADC principles and guidelines governing democratic elections from 2011, culminating in the adoption in 2015, the SADC PF has now developed a model law to facilitate member states to domesticate the principles and guidelines. And as part of that process, we have engaged using the SADC calendar, different member states to facilitate and narrow the gap between what they have in the legislation and the principles. I'm aware that last year in December, for instance, Namibia, where the Electoral Commission and political parties looking at the draft electoral amendment bill. We were in Lesotho last year before the elections, the omnibus bill that was invalidated by the court. We had been part of that process, pre-election process in Zambia in 2019, post-election process in Zimbabwe. They were all under the project. We have also enhanced our collaboration with partners like SADC Secretariat, ECF, SADC lawyers under the project. So the consultant who has been engaged by GIZ is Dr. Chipojo, Claudia, and you would like to then engage with the participants and beneficiaries of the project to respond to a few questions that he has. He has assured me that we do not need more than 30 minutes to be able to conclude that process. And how we are going to proceed to make the process smoother and faster is that we will request for members of parliament and chairpersons of standing committees and clerks of parliament to stay in the room. We will also request colleagues from civil society organizations to constitute another group who will guide in terms of where they can meet. NDI, SADC lawyers, Setso, Chantel, SADC Youth Forum I mentioned, and any other of the civil society organizations I may have omitted who are in attendance. If staff of parliament, please also remain behind. If any of the participants may wish to make a contribution to the evaluation, or if Dr. Chipojo feels it necessary to engage with one of you, you would do so, so that we also benefit from your input. So as we break for lunch, I request that we dispense with this business, or do we break for lunch and come back, or we dispense with the business and go for lunch for good? I stand guided, I'm a Democrat. What are you proposing, honorable members and distinguished clerks of parliament? Do you wish for us to remain behind as we break for lunch, or you want to come back after having had your lunch? There's a proposal that we remain behind. Is that proposal seconded? The evidence is overwhelming. And those who may have a contrary opinion, we are sorry you have lost. But that's in the spirit of democracy. So on that note, we can break for lunch, and remember those who are yet to submit their boarding passes to give to Lorenda, my colleague, who is just by the entrance there. If there are any other administrative matters relating to your travel, please do also confer with them. They will be able to facilitate. Otherwise, I join the SG in most heartily thanking you for attending our meeting. And as we said, we have already constituted a database, which means you'll be a recipient of communication from us as we develop and finalize these tools, so that when they are done, you are ready to receive them and use them, adapt and adopt them as you see fit in your context at national level. Thank you very much. Asante sana, God bless you. Those who are traveling, may the mercies of God be with you as you travel. Maita Basa. Sure. Just to clarify again, so we have requested for clerks of parliaments and staff of parliaments and members of parliament to remain behind. The rest of the participants, you are free to leave. But what we may also do is to share the questions with you through email, and the consultant will communicate. The civil society colleagues, let's meet outside by the couches there, so that we have a different kind of conversation. So, honorable members and distinguished clerks and staff of parliament, Dr. Chikojo will guide in terms of how we proceed. As I said, let's make it as short a session as possible.
Good afternoon.
we may not have made it clear. Those who are leaving for lunch, who are not in the category of persons we have spoken about, there is no afternoon session. We're done. The SG has closed the meeting. Those who are remaining, once we are done with this part, you are also free, and there will be no another afternoon session. We were getting questions. Thank you.
Good afternoon once again, and thank you for staying behind to deal with this evaluation. As Mr. Kurasha has said, we will also be approaching you individually with more questions just to get more information. But for this session, we will just deal with a few questions that are fundamental to the evaluation process itself. I was hoping that we would have someone chairing and someone taking notes.
Paulina, kindly hold your meeting outside.
The idea in this session is to make it a discussion session rather than a question and answer session. It's supposed to be a process where we sit together and put our heads together in terms of looking at the program and how it was implemented. I don't know whether we can get somebody taking notes so that at the end we summarize what we discussed. Could someone volunteer to take notes for us? You can. Yes. So let's get into it and go straight to the questions so that we don't waste too much time. We have about 3 questions that we will have to deal with. The first one is, what, in your own memory, what were the main activities done to strengthen the capacities of the parliaments in the SADC region from 2019 to 2022? I think the program that Mr. Kurasha was describing. What do you remember as the main activities that have been done to capacitate the parliaments in the SADC region since 2019 up to now? Can we list the main activities that were done? That we run through SADC PF to capacitate. If you could use the mic so that everyone can hear and we can capture.
Throughout this period, there were standing committee meetings, and members were had the privilege of having experts who came and discussed on different topics of common interest. This is one area of capacity building.
Yes, sir. Yes, on that, of course, we had the SRHR project, which clearly has been very, very successful. I mean, in our situation in Lesotho, really for most of our MPs as well as the various committees, they learned quite a lot in terms of SRHR. Before, you couldn't even talk about some of the issues involved in that. But right now, most of our MPs are actually advocates of this particular project. So really, I must say that this has been a very, very successful project.
I think
as a standing committee on democratization, governance and human rights, we had a virtual meeting on the role, on capacitating members of parliament on the role of parliaments in curbing corruption.
And do you feel it was, effective, successful?
Yes, very successful.
Okay.
The good thing is it was spread out. It was a virtual meeting. So even members that were not members of our committee could participate in that meeting.
Were honorable members aware of the original objective, the main objectives of these capacity strengthening initiatives?
Probably well, I would, firstly, I would say that maybe for the specific objectives, we're not that, not now reconnecting, we'll reconnect later on. But mostly for human and social development, we've had governance projects for sexual reproductive health and rights, whereby we had consultative meetings, we've had trainings by various experts, and then we had in-country implementations of activities based on the plan of action. And then over and above, we had different model laws that were developed, especially when it comes to child marriage, finance, and then the GBV. And of course, the members provided their input into all these documents for the SADC region. And now we are trying to most of us are trying to domesticate those model laws within our own country. But for the specificity of the different specific objectives for each project, I cannot recall right now.
Thank you. I think there were a couple of other hands on this row. Yes, sir.
Merci beaucoup. En ce qui concerne Madagascar, il faut dire que nos parlementaires, membres du forum parlementaire de la SADC, participent aussi régulièrement aux activités du forum parlementaire, aussi bien aux sessions plénières que dans les travaux des commissions. Oui, nous bénéficions aussi actuellement du projet sur la santé et droits sexuels et reproductifs. Il y avait VIH-Sida, il y avait 4 ou 5 ateliers qui ont été organisés depuis, qui ont beaucoup de succès par rapport aux parlementaires, mais aussi au personnel parlementaire et les partenaires. C'est-à-dire que nous organisons ces ateliers de renforcement de capacité. Nous invitons aussi les partenaires, c'est-à-dire les ministères de la Santé publique, les ONG, etc., etc. Et ce qui fait qu'il y a quand même une prise de conscience relativement palpable après l'organisation de ces différents ateliers de renforcement de capacité. Et nos parlementaires aussi participent à participer à la préparation et à la vulgarisation au niveau du Parlement des différentes lois types élaborées au niveau du forum. Nous sommes actuellement de voir comment les intégrer au niveau de notre ordonnancement juridique. Il y avait la loi type sur les finances, sur les finances publiques, et d'autres encore sur les mariages précoces, etc. Voilà donc à peu près ce que j'ai retenu par rapport aux activités du forum à Madagascar. Merci.
Thank you. Thank you.
Just to indicate that Honorable Ndiweni is actually the chairperson of the Democratization, Governance and Human Rights Standing Committee, under which most of those activities were being implemented, although some of them were done through joint activities. So,
No, thank you, thank you. I think I will be following up with him later on to get more details if possible.
Thank you. Just to add that we were not alerted that it was a project. You know, all these capacity building workshops were coming up. Yes, they were capacity building, but we did know that it was a continuous project where we were maybe at the end of the day going to assess the effectiveness and what we had achieved out of the project.
Yes, I understand that, and thank you for the clarification. Nevertheless, even as the activities were being unrolled and implemented, we can still get a sense of whether we are happy with how they were implemented and whether they were attaining the value addition we were seeking. Yes. Any other hands? Right? Yes.
Thank you very much. Off the top of my head for Malawi, we did have a few capacity building programs for the Parliamentary Women Caucus. And within the SRHR project, there were several activities for members of parliament, including officials from the executive arm of government. Had we had notice of the evaluation, would probably have more information or more detailed information. But the programs that have been run for Parliament of Malawi from SADC PF have been quite beneficial to the institution itself and extremely important for our members of parliament. Thank you.
Yeah, thank you so much. The good thing is that today is just the beginning. We will be making follow-ups with different stakeholders, honorable members, and so on, and giving you the opportunity to feedback to us with much more detailed information, as much as you want and as much as possible. So this is just the beginning. Don't be disappointed here.
I think we were not really aware of this part of the program, what it was going to entail. But right now, I cannot really think out of my head all the activities, all the capacity building activities and the trainings that took place. But of course, there were many. But if we go back, if we get the chance to go back and prepare a list, or if we have the questions, then we can be better prepared. Yes, and submit.
Definitely you'll get that chance. We just need to confirm our email addresses and maybe telephone numbers as well, just to be sure that we can stay in touch. Yeah. The second last question, when you think about all these capacity strengthening activities you are mentioning, what could have been done differently to make them more effective? Is there anything you think could have been done differently, maybe in a better way, to make them much more effective?
Thank you very much. And I think we have also done a lot of meetings on the virtual, which I personally believe that the participation hasn't been so eager because I think people are in the middle of doing some other things. So I believe that if we're able to do it physically, it would be more beneficial because you could actually see that some members were concentrating, some members are not concentrating. As you know, someone would log in while they're driving, someone is going to log in while they're in the office and they're being disrupted. But I think all in all, I think it was also because of the circumstances that we're going through, the COVID, but I believe that if it was feasible, we would have done better. Thank you.
Yeah, thanks. I think when you mentioned COVID, we all know the constraints that we are facing. And I guess that was the major reason for the virtual part. Nevertheless, the advantages and disadvantages are now well known. Thank you. There's a hand up
Yeah.
there. Yes.
What I can say is a regional women's caucus. I know we had a capacity building on the gender-based violence model law, which most of our members from the General Women's Caucus attended. And the question that has been asked, what could have been done better? Sometimes with these virtual or hybrid meetings, you get the internet interruptions, which is sometimes very annoying. And the time difference from country to country, especially where the host is for the virtual, sometimes you get difficulty with the time zone. Like for say, when in South Africa is 11, back home it's already 1. And sometimes those meetings end during the night if it's long meeting. And it's very uncomfortable.
Thank you very much. I think personally, I think they were quite effective, these capacity building workshops, save for the current one, like the one that we are in yesterday. I think much as I appreciate the work that was done by Mr. Kurasha, but the consultant let us down, because dealing with a document that's written by somebody and is not available kills the whole document. So I personally feel the consultant yesterday let us down on the paper on curbing corruption. Thank you.
Thanks for raising that. I see a couple of hands. Yes, let's come back to me, then we go to the back.
Thank you. What could have been done differently? Anyway, what has been done, they were quite effective, I would say. Very much appreciated by, of course, Seychelles and myself. But what would have been done differently? One is that we have different cultures, we have different geographic areas, different countries. Like, for example, Seychelles is considered as a small island state. And it would be much appreciated. Maybe we could organize SADC with other countries to have members, to have exposures, especially when it comes to best practices, so that we can learn from each other, not only in meetings, but at least see on the grounds how things are moving and whether it will be feasible for us to implement into our countries, what not adopt, but at least adapt to our own countries. And then secondly, probably I know that it seems that SADC PF Secretariat is very much, their hands are so full that probably they will need some extra resources to support the countries, especially the standing committees, chairpersons or standing committees. Especially I know that Mr. Kurasha has been running up and down like chicken without heads. And at least you could have more people, not only maybe 2 or 3 standing committees for one somebody to support, then it'll be much more helpful. Thank you.
Thank you so much. I think your hand was up for a long time.
Yeah, I'm the Clerk of Parliament of Namibia. I'm not a member, but because Namibia is hosting SADC Parliamentary Forum, I'm working hand in hand with the SG. What I can say, it's good, the members that have been attending, these capacity building sessions, they are talking, for themselves. My members are not here, but what I can tell you is that they have benefited a lot. As my colleague have said, that if we knew, we could have listed them, so that you see, what impact, it had on the members of parliament. But I remember, that there was a guide to using the SADC model law on eradicating child marriage and protecting children already married. that was discussed also in our parliament. And that was because it came, out of SADC Parliamentary Forum to all the parliaments in SADC. So we have benefited a lot also on that one by also reviewing, the existing laws that we have. So there are many, many of them that we have done. So we have really benefited a lot. So next time, maybe when we know that we are coming, we will list all of them. And I think you said maybe you are going to send us something so that you hear from, the members that have benefited, from these projects. Thank you.
Yeah, thanks for reminding us. I will definitely be reaching out to all of you. We just need to confirm the correctness of the email addresses we have so that we send it to the right people. Your hand was up as well.
Yeah, I think most of the things that I wanted to say, they've been said by my colleague from Seychelles and also the Clerk of Parliament from Namibia. Suffice to say that we should also thank the scouting of the resource persons. They have come up with very, very deep thoughts and very, very elaborate in terms of equipping us with the resources that were needed. However, I think where we can also do better is just like my colleague from Seychelles, the follow-up after we've been equipped. So then what's next? At least if we can also get some site visits to see, is it being triggered? Because we're looking at in the model laws we've done about marriages, we have done about the gender-based violence, but is it really trickling down on the ground? So that is something that we can do even when we talk of agriculture. We've spoken about agroecology. How best can we learn about other practices? Because as much as we've done, as much as we've got we've been equipped with such type of resources, but we would see that some people, I mean, some member states are doing it far much better than the other. And that, as the saying goes, seeing is believing. I think that's something that we can also do better. I submit. Thank you.
Thank you, Mr. Moderator. A very good afternoon to the honorable members. I am here to represent our clerk from Parliament of Eswatini, and I'll speak to this particular evaluation as also an SRHR researcher plus SADC PF desk officer. On behalf of the members have been capacitated so much. And especially with the execution of the SRHR governance project, we want to appreciate the addition of the 8th and 9th outcome, which is based on human rights and governance, which has spoken to a lot of reviews in terms of the SRHR legislative reviews, which has spoken more to issues of high cases of gender-based violence, sexual assault, as well as appreciating what is ongoing to do with women, especially women parliamentary caucus, with reference to redressing issues of impact on women, especially on climate change or on any other pandemics. The youth, the women are the most vulnerable and the most affected, and that speaks to human rights issues. And also in the dialogue activities which we've had, we've also spoken into issues of procurement issues regarding the procurement of COVID-19 pandemic materials with a specific reference to how marginalized the girl child and women were in most cases, whilst at the same time, the very same project speaks to access to SRHR service provision. So this particular landscape has so much positive impact for capacity development, where we also have, as I speak, SRHR champions who are both male and females from within the parliament legislative framework. And there's a lot upcoming. It's true, the honorable members are citing a lot of other issues of resources and also human capital being thin on the ground, but we want to appreciate and further support our collaborating partners who are always there to assist us. And not also forgetting to our consultant, we also have the assistance of African Population Health Research Center, which is also ideal in assisting us as HRSR researchers with the clerks in context of terminologies, because we want to say when we redress the thematic areas, there is such sensitivity. There are cases where you cannot speak to comprehensive sexuality education, but you need to transform that to like life skills education, etc., etc. But I just want to say, to echo what our esteemed honorable members have said, it's a learning curve and we truly appreciate it. I thank you.
Thank you very much. As the next speaker presents his ideas, I'm going to circulate these two papers quickly so that I get the right email addresses from you. So that by the end of the time, by when we leave, I have your contacts. Yes, sir.
Thank you. I just wanted to add that whilst my colleagues were talking of intra-SADC visits, I also feel funds permitting, we could do, we don't live as an island, as a region. We could do benchmarking visits to other communities, Eastern side, even the European side, how they do it. If funds permitting, we could do those benchmarking visits as well. Thank you.
Yes, I was looking at the project documents. It seems they were planned, but they couldn't be done because of COVID. But we can verify. I think they were part of the plan as well. Any other inputs? Okay. To end our session, do you have any specific recommendation that you would want us to take forward? For example, if this program was given a second phase, what would you recommend us to do to make sure that we get maximum value out of it? If we had a chance to do it again, what one or two recommendations would you make to make sure that we get it right?
Well, personally, to me, we have been doing it right. And whatever recommendations, because I can't say, like the feedback you are getting, it really helped a lot in capacity building. But then you see, capacity building is continuous. So I feel it should be given another lifespan. And then whatever recommendations will come from all of us, then it will improve the way we were doing things prior. And that's all I can say, that it should roll over.
I would recommend that when it comes to the development of knowledge tools, have a set standard and standardize them. Because if you look at the two that we're considering, one is more like it's academic, the other one is more straightforward. So maybe if you could have a standard to say knowledge tools to guide members of parliament should be drafted like this, then we avoid a situation where the one is like a research, the other one is more straightforward and easy to understand. Thank you.
Thank you. I'm a staff of parliament in Eswatini. I think it would be best to have like constant or continuous monitoring and evaluation of the project, so that what we are doing now would be contained somewhere. And then now that is it closing? Now that it's coming to an end, then we have an overall with the evaluation that has been done all along, and then we look at the overall instead of doing it at the end.
One of the recommendation is maybe the project could also look at the SADC Secretariat, capacity building for the staff, especially in terms of financial resources. If you look in the room, you'll find out that the whole secretariat is actually here. I think there's 5 or 6 of them, and they are all involved in implementing programs for the whole SADC region in terms of parliamentary capacity building activities. And yet they lack the capacity because they have very limited staff. So if we want to be successful, we need to also provide them with financial resources, with staffing, extra staff. If we want the project to be successful, for it to be, there's continuity in it. Otherwise, we will find ourselves not really finding the project bearing much fruit if we are not providing them the assistance. Maybe maybe the donor, maybe yes, maybe the one that you're representing, the Austrian.
Yeah.
Yeah, the GIZ maybe can have a component for attachment, for secondment. So that will also assist the secretariat on extra allowance. I don't know, something can be.
Thank you. From what my colleague has just said, I think it is a priority, a top priority over priorities that should be taken care of by the governance of SADC. So probably this issue should be on the agenda as a motion or whatever onto the order paper for the next governance meeting, or else I'm seeing that probably by the time, say mid this year, the staff are already saturated, and maybe we shall be, losing some of them. And SADC PF, of course, we should be the loser. And then the other thing is regards to recommendations for, I'm just proposing that we should improve the M&E system in regards to what we've just discussed to the project this morning, and the others as well. Maybe we should develop indicators to monitor all the countries in regards to its implementation, like scorecards, so that we can know, we can be in a better position. SADC will be in a better position to understand the situation on the ground and support those countries that are weaker, and so that they can move ahead with all the strategies or objectives that has been stipulated, and of course support those that are unable to sort of move by themselves. So if we have the indicators, when we can compare and then see what strategies we need to redesign in regards to monitoring and evaluation. Thank you.
Thank you very much. Yes, that side.
Yes, coming back on the funding of the activities of the SADC with regard to individual parliaments. The world is going through difficult times, and the member states in the SADC are no exception. I, for one, I've been around in parliament for more than 20 years, 23 years this year, and we have a problem with regard to capacity building of MPs, let alone capacity building of staff. In my country, we are short of staff, just like the SADC Parliamentary Forum. I know I've had the opportunity to work on the last exercise for the restructuring of the staff of the SADC Parliamentary Forum. So I know how they work, how difficult the job of BOEM, the Secretary General, and all the staff are, and yours also.
the thing is that increasing the contribution from state members is we've done that in the last few years, and it's not sustainable for many SADC member states. And if you want to do capacity building, there's nothing that replaces in-person participation. We've tried with online during the COVID-19 pandemic for the online training, capacity building, holding of